see, I'm not from Delhi. Wherever I go to try and meet people, or even not deliberately, but if I tell anyone that look, I'm in Delhi, I'm practicing in Supreme Court. First of all, the lack of experience in terms of the number of years would not inspire much confidence for people. Secondly, thing is in Delhi, you go around everywhere, you 90% of the people, 90% of the lawyers you will find will say they practice in Supreme Court. So for anyone to look at, say, a young kid with 5-6 years into practice saying I practice in Supreme Court, it didn't sit well with people. But the moment you say, okay, the first question that would come straight away the moment you tell anyone I practice,
Are you an AOR?
are you an AOR? So I think it's not just for the utility for people to know that you're an AOR, that you can be of use for them. It also gives you a kind of a legitimacy to say that okay, you have a practice in Supreme Court, or you can't not have a practice in Supreme Court.
Correct.
So I felt that in fact when I went independent, it took about 2 years before I could become AOR, because 1 year was the commencement period, and then you write the exam and it takes about 1 year for the result to come. So in that 2 year period, it was, I had to tell everyone that, okay, no, I'm not an AOR yet, but I'm taking the exam. Oh, I'm not an AOR yet, but I've taken the exam.
Yeah.
So it just helps. I just think it's very simple, makes it easier. And to come to your other point about how it may affect people, other AORs wanting to brief you or not. I think, and even the other fact that you might be looked at as just a filing counsel, not a arguing counsel, I think that philosophy is a little outdated now. You have more than enough evidence. You see so many number of AORs are, getting cleared every year. I've heard even this year there was a huge turnout. So AORs would, in my opinion, going forward, be the mainstay of any Supreme Court litigation practice. Not being an AOR, of course, you can always get it filed through an AOR, but if a person can directly be in touch with the AOR who's doing the work, that helps. The perception has changed that just because you're an AOR, you won't be arguing matters. I think that was that used to be the perception, but I think it's a bit outdated now. You don't find AORs who say that, okay, we'll just file, we won't argue as many. And also in terms of the future, see, I think it's not yet my time to tell you whether other AORs will brief you or not because you're an AOR, but I can tell you from the, as an evidence of that philosophy not really working out as much is the recent batch of seniors who got designated by Supreme Court. You would find an overwhelming number of AORs.
That's right.
So that gives you an indication that being an AOR doesn't really affect your chances of being a senior, and in future, if you want to be, that is. And for anyone to brief you, I think being an AOR is not really an impediment. If you have a good face value before a bench, if you're known to be good with your work, if you're known to add value, which a senior is expected to, I don't think there'll be any problem with anyone coming to you. In fact, to assuage the fears, if anyone may have any, competitive fears that someone might take away the client, there are two points that I have to that. One is that, look, you don't need to be an AOR to take the client away from someone. You can always get it filed to someone else. So that risk is always there.
Yeah.
And B, a lot of the practice of briefing people goes on the trust basis as well. So people would know it's not going to be a difficult task in that sense. And just to assuage that, many people stop filing practices when they reach that age, that experience, when they're looking to be a new senior. I mean, far away, as I said, but these are just my observations, hearsay, as you can say.